Counsel, Ms. Richins, it is my practice to ask all the lawyers and the defendant to stand in respect for the jury as I read the verdict. I just don't want you to be surprised. Okay. Mr. Bloodworth, are we ready for the jury?
Yes, Your Honor.
Ms. Lewis?
We are.
All right.
Okay, folks, buckle up. This is a moment everyone in the courtroom has been waiting for. The judge is about to read the verdict, and the tension is off the charts. Quick legal tip. Standing for the jury is a courtroom tradition to show respect for their decision, but you can feel the nerves radiating from every lawyer in that room. This is a high-stakes moment.
Folks, please have a seat as you come in. Please have a seat. Ladies and gentlemen, would the foreperson you've selected please stand? May I ask you a yes or no question? Has the jury reached a unanimous verdict? Would you please hand the verdict form to the deputy, and you can have a seat. Thank you. I'll take that. All right. Counsel, Ms. Richins, please stand. Count 1, aggravated murder. We, the jury, unanimously find that the defendant, Corey Richins, is guilty of aggravated murder. We, the jury, unanimously.
And just like that, guilty on count 1, aggravated murder. Notice the specifics? The jury highlighted pecuniary gain and lethal administration of a substance. That's important because the law treats premeditated, financially motivated murder as particularly egregious. Audience, here's a question. Would you be surprised if this pattern continues in the next counts?
Agree that the prosecution has proved the following circumstance or circumstances regarding count 1 beyond a reasonable doubt. The homicide was committed for pecuniary gain, and the homicide was committed by means of the administration of any substance administered in a lethal amount, dosage, or quantity. Count 2, attempted aggravated murder. We, the jury, unanimously find that the defendant, Corey Richens, is guilty of attempted aggravated murder.
Whoa, it's not stopping there. Now we've got multiple counts of insurance fraud and even forgery. This isn't just a violent crime. It's a calculated scheme. The jury clearly saw the bigger picture. You can almost see the shock ripple through the courtroom. Like, how many layers of crime can one person commit? Makes you wonder about motive, right?
We, the jury, unanimously agree the prosecution has proved the following circumstance or circumstances regarding count 2 beyond a reasonable doubt. The attempted homicide was committed for pecuniary gain. Count 3, insurance fraud. We, the jury, unanimously find that the defendant, Corey Richins, is guilty of insurance fraud. Count 4, insurance fraud. We, the jury, unanimously find that the defendant, Corey Richins, is guilty of insurance fraud. Count 5, forgery. We, the jury, unanimously find that the defendant, Corey Richins, is guilty of forgery. It's signed by the foreperson. Please have a seat.
Here's a fascinating peek behind the curtain. The judge is confirming each juror individually. This is rare in most trials. Usually we just hear verdict accepted. It's a check to ensure unanimity and accuracy. For viewers at home, imagine being in that jury box. Every nod feels like a heavy responsibility. Could you stay impartial under that kind of pressure?
Madam Foreperson, is this the verdict that the jury reached unanimously?
Yes, it is.
Okay, you may have a seat. Ms. Lewis, Ms. Nestor, do you wish the jury to be polled?
Yes, please.
All right. Folks, I'll ask you the same yes or no question, one at a time, starting on my left, working this way. Front row first. If you could show me your lanyard number as I ask you. Juror number 5, is this the verdict you voted in favor of?
Yes.
Juror number 4, is this the verdict you voted in favor of? Juror number 3.
Yes.
I can't see your name, I'm so sorry. The foreperson, I just need to ask you again, I'm sorry. Juror number 2.
Yes, it is.
Juror number 1.
Yes, Your Honor.
And the jury is officially dismissed. They've done their job, and their verdict will carry serious consequences. The judge's reminder about confidentiality is crucial. Even though you can speak freely now, the deliberation room's trust is sacred. Drama aside, this is the backbone of the American justice system in action. Think about it. These 12 people literally decided someone's fate.
Sir. Juror number 8.
Yes.
Juror number 7.
Yes.
Juror number 6.
Yes.
All right. Counsel, is there anything further on this case before the jury is discharged? Mr. Bloodworth.
No, Your Honor. Thank you.
Ms. Lewis.
No, Your Honor.
All right. Ladies and gentlemen of the jury, this trial is now finished. Thank you for your service. The American system of justice relies on your time and your sound judgment, and you have been generous with both. You serve justice by your fair and impartial decision. All of my previous admonitions are now lifted. You may speak about this case with anyone or with no one at all. It is entirely up to you. You might be contacted in the future by the press or by the lawyers. You do not have to talk with them or with anyone else, but you may if you would like. The choice is yours entirely. I'm now turning to the attorneys and instructing them to honor your wishes as officers of the court if you indicate that you do not want to talk about this case. If you do talk about the case, please respect the privacy of your fellow jurors. The confidences they may have shared with you during deliberation are not yours to share with others. Thank you, all of you, for your service. Please rise for the jury. All right, please have a seat. Ms. Lewis, we need to get a pre-sentence investigation report, and we need to set sentencing. I imagine, Mr. Bloodworth, that the state would request that that be special set.
Yes, Your Honor.
Okay. Ms. Lewis, does defendant waive the 45-day limit for sentencing?
Yes, we will.
All right. Let me call up my calendar. Should we be looking in May, Ms. Lewis?
That's fine.
Do you have a sense of it, Mr. Bloodworth?
Fast forward a few weeks. The court is setting the sentencing date. A pre-sentence investigation report is standard procedure to help the judge decide the appropriate punishment. For viewers, this is a reminder that a guilty verdict isn't the end. It's just the next chapter in the legal process. Any guesses on what the sentence might be based on the evidence we've seen?
April is not possible. In May, do you have a sense of when would be appropriate?
Your Honor, can I step back and talk to the victim's family?
Sure. And Ms. Lewis, if you need a moment to confer with anyone.
Your Honor, any day in May works.
Without having to move something, which I am, of course, willing to do, I could do it during the week of May 25 or the morning of May 13. But if those times don't work, or if the week of May 25 is too far out, I'll move something to accommodate council schedules. Ms. Lewis, why don't I begin with you?
Either of those days would work for the defense.
Is a morning enough time?
Yes, sir.
Ms. Lewis?
Yes.
Okay. We'll set sentencing for 9:30 a.m. Wednesday, May 13. We're hereby referring Ms. Richins for the preparation of a pre-sentence investigation report. Ms. Lewis, anything else on the record today?
No, Your Honor.
Mr. Bloodworth?
No, Your Honor.
Ms. Richins, I'll see you again, May 13, 9:30 a.m.